All right, got to kick it off. Put the streaming stuff up here. Usually, by the way, this time of year, numbers have usually dropped off earlier to this, and they start picking up by about the week 10 material. So it's yeah, it's a little bit surprised that there's. Although that said, you've also probably got assessment due as well all over the show. So maybe that's the thing. No, it doesn't like me. It does not like me at all. Why is that not working? Well upon well upon well. Sorry guys, moving drama. Oh, is there a live button down there? No, YouTube. This one. Maybe. That's why. Okay. Sorry for that. Property. All right. So again, it's a useful area of law to know, but it's fundamental in terms of business decisions. I don't think it's of certainly as much importance as things like contract and tort. So while we're going to go through it because the Accounting Society mandates that we have to go through and talk about this stuff. Just make note, some of the cases are a little bit obscure, and the situations and scenarios are not day-to-day things, and that kind of makes sense because when we're talking about property and particularly what we call real property or land, the transactions involving land don't come up very often either. So just make note that that's why this is. This stuff can seem a little bit abstract and not always as directly useful in terms of particularly our accounting skills and that sort of professional aspect. All right, so what I'm going to do, I'm going to spend a bit of time going over definitions. Land law, and also personal property as well, uses a lot of archaic terms, old English words to describe things. They're a little unusual. Again, it's part of the course, and it will be accessible. But I'll be very clear to express to you guys which parts are going to be the key bits that you're really going to need to know that you're going to be assessed upon. And the key thing to note here is that this course is not about the real estate industry. It's not about the going and buying and selling of large things of land. Contract law is still a big part of the subject, but the underlying knowledge of how the dynamics of land and land ownership doesn't form a big part. I'm not trying to downplay this in some way. It's still quite useful to know. I just think in my own experience that some of the other parts, for example, last week we talked about trusts. In my experience, in terms of an accounting background, I found that much more useful. That's why I put it in. This stuff has classically been in these sorts of subjects, and it's often assessed. One of the reasons that it's, again, assessed habitually is that it's a good example of having a series of rules or principles, having some facts to apply those things to, and then coming up with a result. And so in terms of a substantive area of law, it's quite a useful one to demonstrate that you understand the process of law being applied to particular scenarios. So that's a little bit of why we've retained a reasonable chunk of this in here. So I'm going to go through definitions. We're going to talk about real property. Real property, by the way, is land. So if you hear that term, it's a technical legal term. It just means land and things that are attached to land. Buildings and fixtures. All right. Personal property is things that aren't attached to land. And note that when we're talking about personal property, and you've obviously, as accountants, you appreciate the distinction between tangible property and intangible. Next week, we will be going through intangible property, or at least the intellectual property components for this subject, which is, again, is a useful thing for you guys to know. For this particular week, it's really about defining things, defining and describing them, to get you guys a good handle of how these things sit. The two other areas that we'll look at, and again, these words, you may or may not have ever seen these words before being used in this context. They're both legal terms. Bailment is the duties that a person has when they are in control or possession of someone else's stuff. All right, and this bailment sits separately, differently, and distinctly from both contract and tort. It's a series of rules and duties that sit different, and it's actually older. It actually predates contract and tort, thinking how old these things are. And the idea is that you often do have contractual duties, but not always. If you're picking things up from your, taking something on behalf of your brother-in-law across the city, all right, they've given you something for you to look after, there are still laws that apply to the doing of that, even in the absence of no contract. And we'll remember in torts, we talked about things like trespass to property. Well, things can still arise independently of any wrongdoing. Tort is about wrongdoing and being allocated fault to a particular person and the cost associated with that fault in order to compensate somebody. Bailment exists independent of that as well. It's just a person who takes stuff or has stuff. They have duties. Not very big duties, but they do have some. And liens are a particular type of legal obligation that you can place across property. Some rights, some different rights, a packet of rights that you can have in order to withhold usually someone else's property. And the classic example is, for example, something like a car mechanic has a right to hold onto a car until they've been paid. All right, and again, this operates and sits independently from contractual obligations. Okay, so the first thing to start with, and it's often something we don't think too much about, is what is property? What does it actually mean? Because the thing is, this is a law subject, and when we're thinking about property, it's actually nothing to do with the things themselves. Everything in law is about the power dynamics between people and how those relationships are established. And the key thing to note here is that when we're thinking about like property, we're not really thinking about the thing. It's people's relationship to the thing. The powers, rights, and also obligations and duties that are associated with property itself. And so when we think of ownership, it's that the ability, the recognized ability in law for other people in society to recognize that a particular person or persons or entities have rights over things in the world. This is not being very carefully mapped out or defined by the courts. It's really, arguably, it's a question from philosophy. The best case in this is around about the turn of the century, a case called Yana and Eaton, where they were talking about indigenous hunting rights, whether or not things in the wild are owned in the classical traditional sense. So really, before they could answer that question, the High Court had to discuss, well, what is property? What is it to own something? What's that necessary connection that exists between the thing in the world, the person who owns it, in inverted commas, and their relationship between that person, that thing, and everyone else in the world, in terms of that recognition. Okay. Several. I think I've got a few slides where we're defining things. I just mentioned before that when we use the term property, we make this division between things that are to do with land, things that are either the land itself, and things that are affixed to the land. They're called fixtures, and they flow with the ownership of the land to the people that come afterwards. And we call that real property. It comes from real, Spanish for thing, I think. Oh, don't quote me, people that speak Spanish. I learned this a long time ago. I think it's real, but you'll be very, very unlikely to hear these terms used, because even lawyers, when talking to clients, will not use this term, real property. But when you hear the term real estate, that's actually what it means. That's where it comes from, the idea of real property. Estates is a bit more complex. We'll do that later. Okay, so that's real property, and personal property is everything else. Things that are not attached to land. And again, we make this distinction that we'll talk about later on. Things like chattels, things that you can pick up and move around. This mouse is a physical thing, not attached or associated with land. And that is different and distinct, for example, from the carpet on this floor, which is attached to the land and affixed to it. And it's, again, in the real world, it doesn't make much difference. Things are things are things. But in terms of the law, the rules that apply to land are a little bit different and distinct from the rules that apply to personal property. And they use this term chattels to describe physical things or tangible objects, and choses in action. And again, this is a term you almost never hear. Lawyers might use it when talking to each other, but even then they very rarely do. That are rights that at law are recognized by other people, but aren't associated with physical things. So things, again, like the right to a debt, for example, a right to have shares in the company, a right to a particular trademark. None of those things exist as a physical, tangible thing. And it's hard for you guys often as accountants, because you guys know how to value these things. Part of your professional skill set is to be able to analyze the value of things that don't exist. And so that's at law, we use that particular term to describe those things broadly. Okay, so for the purposes of this lecture, I'm going to start by talking about land, real property. I'm going to go through that. And again, it's not particularly useful, I think, in terms of your day-to-day business transactions, because largely transactions involving land don't happen very often. They're not day-to-day occurrences. But it can be helpful to know some of these things, and a little bit of history too, as to how these things came about. All right, so you guys might have heard the expression crown land. Have you heard of that expression? Does that sound familiar at all? The idea that the government, in this case the state of Queensland, owns vast tracts of land, right? They've got parks and they've got roads, and they've got all sorts of other bits and pieces. Yeah, sure, they might outsource that ownership to councils or to other stat bodies, but fundamentally, that land is essentially owned by the government. Now, the thing is that if you actually go back a few steps in terms of the original acquisition of land in the first place, and we come, looking around the room, some of us come from countries where people have lived there a very, very long time. And it's difficult to determine who were the first people there. All right, and you might recall also from the first and the second lectures, we talk about the notion of transferring land through nation states. The idea of conquest. You conquer someone, you displace the original rulers, you become the rulers. You've got secession or treaty, where two nation states agree that one tract of land that belonged to one lot now belongs to another lot. Okay, and the third type of way of acquiring land, does anyone remember what it is? The one that was applicable to Australia? It's terra nullius, land belonging to no one. All right, if instead of coming to Australia, because there's a little bit of argument about that post-1992, but if, for example, James Cook had claimed Antarctica at the same time, where there literally were no people, land belongs to no one. And the idea is, at that point in time, it's the sovereign. The sovereign owns the land. And this is a realpolitik thing. What do I mean by that? It's the person with the army, the person with the biggest sword in the land can assert that ownership. And so we think of the this idea of land, and we think about our own individual little packets of land. And I've got a little house around the corner here. I'm not sure if you guys have family property, either in Australia or in other countries. We think about the property that we have, and it's ours. All right. What's stopping other people in the same country from coming and just taking your land? Well, we've got laws, right? Laws and rules. It's registered title and this, that, and the other thing. People come into your land, you've got certain packets of rights associated with that. What's to stop? Don't want to name names of countries, but let's think of one powerful, very advanced manufacturing nation without a democratic government might want to come along and take the land. What rights do you have in relationship to your land? Well, as an individual, none. You have that's only manifested through essentially the government itself and the ability to defend that land or defend the nation as a whole. Gary probably knows this. I'm not sure if the rest of you guys have heard of something called the Brisbane Line. You know what I'm talking about? No, maybe you haven't. Okay. So, during the Second World War, you guys are aware that the Japanese were planning to take Moresby and then use that as a staging post to invade Australia. You probably should be aware. I even talked about it in this class. The Battle of the Coral Sea, all that. Anyway, do you know what the people in Brisbane did? This is very, very funny in relation to North Queensland. Do you know what they did? They put, those concrete, they're like massive caltrops, big four-pronged concrete things that you put in the ground, all right, and it stops tanks and cars and things from getting through it, all right. Do you know what the Queensland government did, or the Australian government? They put a line of those. I'm not making this up. About 50 kilometres north of Brisbane. It's called the Brisbane Line, and basically they were just going to give North Queensland to the Japanese, and then defend from that point. Yeah, there you go. You've learned a little bit. So when North Queenslanders get a little bit grumpy about their brethren from the southeast, and you guys would probably lived here long enough to see this distinction. Have you noticed it culturally? You haven't seen. There's a very strong sort of cultural difference between people in region and north, central and north and far north Queensland and western Queensland, and what they call the southeast, which is Brisbane, the Gold Coast, Sunshine Coast, and Toowoomba. It's very much an us and them mentality. It's like daylight savings. Daylight savings in the north is political suicide. All right, and it sounds crazy, doesn't it? It sounds crazy, but that's just the way it is. And so people of North Queensland have not forgotten the Brisbane Line, where those things were put up, where they were just like, here you go, Japanese, you just have that. You just have that. We'll defend from here. You just have that, but we'll if you come any further, no. But again, it's realpolitik. If the Japanese came and they had enough aircraft carriers and troops to take it, they take it. That's how essentially that's how the world, up until 1945, that's how the world worked. What happened in 1945? Yeah, what specifically though? Some very specific events happened at the end of the war. Hiroshima and Nagasaki, and the United Nations that was formed at the same time as well. So it became abundantly clear, if humanity wants to go down that path again, that is the end. That is the end of it. We're long surpassed the ability for one nation state to destroy all the other nation states. All right, and most of you guys don't remember, but people my age and older in this room who do, growing up in the height of the Cold War, where you've got the two biggest militaries on the planet with nuclear weapons pointed at each other, ready to push. And a couple of times they got really close, pushing that and ending life on the planet. So appreciate these things do happen. And we are living in a century where things might happen again. So just lay that one in the back of your mind when you go and get a mortgage for $850,000 like my brother just did last month, because you might spend your whole life paying off a plot of land, and it's only going to be as strong as the sovereign to defend it. All right. So anyway, in Australia, we still have a monarchy. The Queen of Australia happens to be very conveniently the same as the Queen of Great Britain, but there's no crossover in powers. Right? The Queen has no power in relation to Australia. She's essentially a figurehead monarch. So that when you go, have you guys done the citizenship ceremony? If you guys do go through, for those that are seeking residency and doing all that stuff, I did the citizenship ceremony and I sung the New Zealand national anthem to the tune of the Australian one. But that's fine, you do the thing. And then they have a big cutout of the Queen. So like they're still the formal head of state. And we use the expression Crown land as what was called the original grant. The land that was taken, in this case through terra nullius, inverted commas, land belonged to no one. It's now all owned by the British Crown. King George III, I think, at the time, 1770, around about that. And that claim in 1770 is only as strong as the people were able to defend it. If the French or the Dutch came along and said, nah, this is our land, then we would be, trying to think what we'd be singing. We would be singing, what's the French national anthem? Can't remember. I can't remember. I can sing it, but I don't know the name of it. Oh, it's embarrassing. Anyway, but this idea of of being able to defend it flows from sovereignty. It flows from the people with the armies that look after, take over, conquered, or got through treaty a packet of land. So you will hear that expression, Crown land. It's owned by land owned by the state of Queensland. Now, I say Queensland and not the Commonwealth of Australia. That's possibly a little untrue. There was a case. It wasn't Yana and Eaton, it was around about the same time, where the High Court in regards to uranium rights, I'm not sure I talk about this in class. There's an idea, by the way, of this thing called the royal metals. The state of Queensland owns all gold, silver, I think gems as well, diamonds and stuff, under your land. They own it. And the issue there was that, well, could they own uranium? Because uranium wasn't valuable when the Crown originally, claimed Australia. And the British took it in the 1770s. Uranium wasn't a thing. Could the Crown actually own that? And the High Court said, in answer to this question, yes. In answer to another question that you didn't actually ask, but we're going to tell you anyway, everybody seems to think it's owned by the states. It's probably not. It's probably actually owned by the Commonwealth these days. But they didn't carry on down that path. Remember, the state governments have no money. And the High Court jumping in and saying, oh, well, actually, the Commonwealth government owns all the gold as well. Would not go down well. Right, I'm going to move on to that. A couple of other terms. I'm going to talk about the Doctrine of Tenure. I talked about, again, in the history class earlier on in the semester, the idea of this realpolitik. When William conquered England in 1066, he became king through conquest. This land is now my land. Why? Because I have the biggest army. If anybody has a bigger army, it can be their land. But no one does. Therefore, it's mine. The trouble is, if you've got a king with an army, they're not very good at running things, are they? And so this idea of outsourcing, essentially. So the king gets a bunch of people together, call them barons, and say, you get Sussex, you get Northumberland, you get Cumbria, you get Cornwall. All right? But I will grant you this land on the condition that you provide me some stuff, be it money, be it troops or horses, be it food, be it religious services. All right, and this idea of having this, essentially this regular tribute back to the higher lord, because the thing, as a baron, you can't rule all of Northumberland or all of Cornwall. You have to outsource to other people. So you, as the big baron, says, oh, well, I'm the biggest bully of this land, because the king says I am. I'm going to then outsource this part to you, this part to you, this part to you. And you will owe me this duty to have and give military service, religious service, food, troops, horses. All right, and so this idea of creating these lesser and lesser grants, so to speak, and essentially a pyramid, is called subinfeudation. And the system is known as the feudal system. And the key thing to note is that no one owned any land. The king did. The king owned everything. All right? But in relation to a person who's at the bottom of the pyramid, it really doesn't matter whether the king owns it or the lord directly above you, who you have to give your stuff to, owns it. It really doesn't make any difference. You don't own the land. You can never own the land. The feudal system sucked. You could never, you'd work the land all your life and never own it. At least not in the way that we would think of owning stuff. And this hung around for quite some time, hundreds of years. But eventually, people realized incentives work. And I love this. Most of you guys have studied economics at some stage. You appreciate incentives actually work. People who toil the land because they were called serfs, S-E-R-F, comes from the Latin word servus, which just means slave. The English word serve flows from that as well. You're working, but you can never own it. And you have to give some fraction of what you make to your lord. And if the lord wants to take the whole lot, well, you starve. That is not a fun life. And what's the incentive to work hard? If you produce lots of stuff, your lord takes it. It's not a great incentive system, is it? And they didn't realize that as a result, this didn't work particularly well. And so they slowly phased this out and gave people the ability to actually own the lands, which is going to be the next slide. And just note, though, this idea of the feudal system, it was completely phased out before Cook came to Australia in the 1700s. So it's never been part of Australian law at any stage. But the very, very last point there, the concept, though, of the crown as the highest power, being able to give land or grant land to people, is still part of our law. The crown, if it wants to, can give land to people. And again, I'm thinking of the state governments. The state governments have the power to do that. And also, the state governments have the power to take it away. So the state government can giveth, and the state government can taketh away. If the state government wants your property, it can take it. Now, traditionally, the state government will do what? If they want to take your land, they will. If the state government wants your land, what do? They give you money, usually. It's a process called compulsory acquisition. Strictly speaking, though, the states don't have to. As the grants. Now, the position is actually different from the Commonwealth. The Commonwealth wants to build an airport. They can acquire people's property, but they must do so on just terms. All right, there's a movie, very, very Australian movie called The Castle. If you've got any interest in this sort of area, you can watch it. It's quite. If you want to laugh at Australians for 90 minutes, it's a bit of a laugh. And that is basically about that rule. The Commonwealth must acquire property on just terms. State governments, strictly speaking, don't need to. Habitually, though, they do. They will actually pay money in order to acquire land. All right, it's the doctrine of tenure that flowed from the feudal system. We also have the idea of this system of grants. We call this the doctrine of estates. And it goes something like this. If you have land, you can place restrictions on it, on that packet of land itself. And those restrictions can stop or change or alter the way the land gets transferred. This used to be the case in England, that land was under a system of grants what's called fee tail. Has anybody heard of a British author called Jane Austen? No one's ever heard of Jane? No one's heard of Jane Austen? Yeah, Jane's heard of Jane Austen. What was the key factual situation in Jane Austen's Pride and Prejudice? Pride and Prejudice. The key factual point in that whole thing, from a legal point anyway, is that the owner of the land, which was in the style known as fee tail, had 5 daughters. What was the problem with fee-tail? It could only be transferred to male heirs. And so the whole story is based around the lord, the owner of this property, trying to marry his daughters off well, because only men could inherit the land. And that was a restriction that was placed on the grant of land itself a long, long, long time ago. Now, this doesn't exist in Queensland anymore, although it actually existed until quite recently, like into the 20th century. You could have fee-tail land. There is actually another type, I think, femere or something, which was the opposite. You actually could have only female inheritance on it, but that was very, very rare. But the idea is that there are types of grants across land that people could have that are, some are greater and some are lesser than others. And the greatest grant that a person can have is what's called land in fee simple. There's lots of strange, obscure English phrases that have come into this. Fee simple, or freehold land, is land that is owned by somebody and has no restrictions at all in terms of who can have it and in terms of what can be done with it. That is the greatest grant of land. Now, there's other types of grants that are lesser. They are a lesser or smaller packet of rights. The idea is, if you've got a grant, powerful or a highly ranked series of rights, you've got a packet of rights associated with that. If you own your land, let's just say, hypothetically, you guys own a house just around the corner in Riverside Gardens, and you own it, and you've got no mortgage, you've got no nothing. You own the land in fee simple, it is yours. So what can you do with it? You can rent it out. All right. And if you're renting it out, strictly speaking, you're giving possession of that place to another party for a fixed length of time for payment of money. So they, while they pay that money, they have some rights. They have the rights to include and exclude people from it. Sometimes they have the right to rent it out, to sublet. Usually they don't, but again, they could do. They have a right to quiet enjoyment of that land. And I don't. I have taken the money to rent it out. I've created a lesser grant across that land. Another type of grant, I've got one here, is can associate with situations, sometimes where it's husband and wife. You can find, this is not actually, this still happens, this is a reasonably common thing. Husband and wife have a property and it says, look, if one of us dies, the other one holds this property for a life estate. In other words, it's keyed to that person's life. The idea being that person could stay, utilize this for as long as they're alive, but when they die, it doesn't go to their children or their estate, their deceased estate. One of the tricky things about that, and it's a bit hard to get your head around, but it's quite logical, is that you can have a life estate and sometimes you can assign them. So there could be, for example, my house around the corner, I could create a life estate that's keyed to my life. So in other words, I will have this property until, oh no, not me, okay, I'll give it to my child. My child can have it for as long as he lives, all right, but that interest reverts back to me when he dies. And again, if I'm already long dead, it'll revert to whoever I'd listed in my will. So the interesting thing about that, though, is that if I've assigned it to my son, I've created a life estate, it's keyed to his life, but that doesn't mean he, strictly speaking, has to be the one that lives there. He could assign it to someone else. So you could actually have this situation where you could live in a property, all right, and ownership of that property could be contingent on somebody being alive. So these things can be a little bit tricky, as you could imagine, in terms of transferring land. But often it's used in a situation where the person with a life estate does actually live there. It's pretty rare to have that transfer. Now, leasehold land. So you've got an estate in fee simple, which is the strongest, widest, largest packet of property rights you have associated with land. You get the right to sell it, you get the right to rent it out, you get the right to exclude others, you get everything associated with that packet of land. One of the things you can do is lease it out. And now again, I was thinking before in terms of residential tenancy, where you could rent it out for $300 a week, each week, pay periodically, or you can lease it. Actually create a fixed-term lease. Less than there, but short-term lease is up to 3 years. Long-term lease is beyond 3 years. Long-term leases must be in writing. That's just a feature of our land law. Strictly speaking, short-term leases don't need to be, but they almost always are. All right, and yeah.
In default, what is the applicability of the rights of the land? Is it like freehold land generally? And then is it an option of the person who is purchasing the land, the owner of the land, to make it like anything else like right estate?
Okay, if you have a higher grant.
No, I'm just asking generally, not because we just new to it. So
Okay, the idea is if you've got a high ranking right in relation to land, usually you can create a lesser right. So if I have a land owned in fee simple, I could, in theory, create a grant of a life estate and give that, transfer it to someone else. Transfer that, and the idea is that somebody else has all of the things associated with this land, the right to possession, the right to lease it out, the right to create smaller leases. The one thing they don't have is, and often they have the right to alienate it to third parties. The one thing that doesn't transfer or restricts that in some way is that at the point in time that assignee dies, it reverts back to the original owner in fee simple. So it's the idea is that this person can always create a lesser right. And often by creating this lesser grant, this lesser packet of rights, usually they do it and restrict it in some way and get some form of benefit. So if I have my property around the corner, or say I've got a factory in Garbutt, I might want to create a lease for a company that wants to use it for 10 years. Whether or not they pay periodically or pay up front or pay at the end, it doesn't really matter. And the idea is, after that 10 years are up, control of that property reverts back to me.
It's in the case of leasehold, isn't it? It's like the option that you're giving the right.
Yeah.
But I'm just saying generally,
Yeah.
what's the right on the land in Australia other than Crown land?
In terms of people.
We have different types of categories of land.
Yeah, well,
Like in India, we have various categories of land.
yeah, I'm interested. You
That is like everybody doesn't have freehold right on every
Sure.
property.
Wow.
So some property or some land is only for a specific purpose.
Oh, okay.
Can't be used for any other purpose.
Well, there you go. Okay, that's really neat. There are certainly things. A suburb yes, it does exist. It exists in Queensland, where you have land which is owned by entities and then is leased out. So the example, just think of an example from New Zealand actually. There's a suburb called St John's in Auckland, and house prices are much cheaper in St John's than everywhere else in Auckland. And the reason for that is that the church had a grant from the Crown 200 years ago. And so they have in control of all of the land, and they've essentially created 99-year leases. And so if you are purchasing a property in St John's, you purchase it and you purchase the lease on it as well. And again, you guys as accountants are probably much more familiar with the systems of valuing. The value of a lease is a difficult thing to calculate, particularly when in relation to options to renegotiate or options to continue a lease to a certain period of time. And it's an important consideration in business when doing that, because they become an actuarial exercise in valuing these things, and it can be quite complex. And the idea is that if you have this high-level lease, and you can, when you create, if you've got the estate and fee simple, you can create a grant of a lease that says this person can't sublease, right? Or they could say you can sublease. And the same with residential tenancy. If there's an owner of a house in fee simple here, and again I'm thinking about my house in Douglas, I could rent that out to some people. Then there's a little box in the standard form that says, can they sublease? And if I tick that one there, those people get a more powerful right, because they can then get tenants in themselves and have and manage those. These guys owe the money to me. I don't know anything or even care about the people that they sublet to. They owe no obligation to me at all.
But they have the superior power, isn't it? So they can locally contact whenever they want.
That's right, in relation to these guys, yeah.
Just be a pending case, and they will be like hanging.
Yeah, you find that with leases, because they're also almost always contractual documents too, so that not doing things according to the conditions of the lease is breach of contract. So it falls under that area as well of contract, as well as in land law. But going back to the original point about the different types of grants, I went to Tonga a few years ago. All land is owned by the Crown. You can only get leases for a length of time. And do you want to know a couple of things about Tonga? It is not good. No, that's the one thing about Tonga. It's not good. There's no incentive to invest. People don't want to invest in Tonga. It's just not, because of risk. You guys understand how risk and return works, right? If you can't own the land, even worse, the Crown retains the right, and they use it periodically to kick you off your land. That's really problematic. Friends of mine come from Fiji. And Fiji's a really interesting place. If you guys want a case study in democracy, and the interaction between indigenous Fijians and Indian Fijians, because you guys are probably aware they had a few coups. So it's a democratic country, but what you found is that when the population shifted from being 51% indigenous Fijian and 49% Indian, and the moment that changed over like that, because the two cultures don't mix, they don't mix very well. So as a result, when that changed over, all of your parliament changed. And so the indigenous Fijians, they controlled the military. So they had a coup. And then, of course, a bunch of Indian people leave, go to New Zealand, and then the population demographics change. So it's a really, really interesting place. But again, similar things apply in terms of the risk that you have as a government. Taking land over is really problematic. It's really, really problematic if you just say, oh, no, we're going to take this and nationalize it. And that's why this thing in Sri Lanka, the ports, you guys are probably aware about Chinese port like that. You guys know what I'm talking about, eh? This is big news. You should be worried about things like this because it's the government. In theory, the Sri Lankan government could just come and say, no, we'll just take this port back over again. But in practice, you can't, because if you're willing to just take over something without offering compensation, the will for external people to invest in your country very, very quickly goes to zero. So you just have to be a bit mindful about that. Some countries have constitutional restrictions. Australia, the Commonwealth government can't take the Port of Darwin back. They can't. They're not allowed to. They have to pay. Most countries don't have that. Okay. Just also a couple of things to note here. Look, if you guys are acting as financial controllers, you're going to be involved in this stuff. If you are acting as financial controllers and for entities in Queensland, you're going to need to know these particular statutes, particularly the Retail Shops Leases Act and the basically, what's the other one? The RTRA. But you'll know the RTRA if you have any disputes with your landlord. That's residential tenancy. It is very easy to read. In fact, I would expect if you guys have difficulties with your landlord, for those that are renting here, I'd expect that to be a good place to go and actually have a read and see what the rights and obligations of the parties are. I think you guys would have enough power to do that. All right, because we accept that powerful parties, BHP and Rio Tinto are organising contracts for their stuff. They've got big legal teams, but we know that you guys going as students trying to rent a place, we don't have lawyers, we don't have powerful things. All of the rules of contract law, we kind of have to leave that aside and let Parliament take care of it and say you need to do this, this, and this. You need to fill in the form, you need to pay the fee, you need to have a bond, because this is just a clean way of doing it. All right. Anyway, co-ownership. This may or may not be in your exam. May or may not be. It was last year, and this year's exam looks suspiciously like last year's. Okay, so things to note. These are actually terms you probably want to... They're not super important, but they might come up in your life. It's the distinction between tenancy in common and joint tenancy. All right? Now, if you have... And this again, I'm going to put my counting brain on for a second. If you... how many people in this room right now? 6, 7, 8, 9, 10... There's 12 of us in this room. All right? Let's just say collectively, we go... each put $100,000 in and buy a warehouse in Garbett. Big warehouse. $1.2 million. Good work. Good work. How is that going to be owned, do you think? So each of us is 12 people in this room. What share do you think each person for that might have in that? Yeah, you think so. That's right. And that's logical. That is tenancy in common. As accountants, we look and say, well, that's completely logical. It is. However, like a lot of things in law, from time to time you have to suspend disbelief, take off our accounting hats and just go, what is this? Because joint tenancy is not the same as tenancy in common. Tenants in common, the idea is that, look, if we've all bought this warehouse and I just go, oh no, I just need some cash. I found this guy who wants to pay me 100 grand. I'm going to go and sell my share, all right, to this person. See you later. See you guys. And I could just do that. Tenancy in common allows you to have shares in real property. Real property, I mean land and buildings. Okay? Logical shares of a fixed proportion that can be alienated separately. And by alienated, I mean sold, disposed of, transferred, gifted, put in a will. That's tenancy in common. That is not the other one, which is joint tenancy. Joint tenancy is where the parties jointly own it, right? But they don't have indivisible shares. You jointly own it until you die. What would be the point of that? Point of that is if it is family land. The idea is that the elderly parents have got 6 children. We're going to jointly own this property. And so if the parents both die, it transfers to all 6 of the kids. Okay. How many siblings do people have in this room? I've got 1. Any advances on that? Who's got the most siblings? Who's got the most brothers and sisters? Oh, I'm quite interested. 2, 1. Gene, how many kids? You've got 4? 3? 3. Justice? You got 1. Eric? None. How many at all? So we got 1 as well. So was it 4? You got 1. Who had 4? Over there. Gene, you got 4. 4 siblings. Do you get on very well with all of your siblings? So if hypothetically, all 5 of you were gifted some land, some long lost relative or parents or whatever like that, have somehow gifted you some land, all right, and it's owned jointly from the 5 of those, all right, how do you think this would work with this right of survivorship? Do you think that would go down well in terms of co-ownership? Because the 5 of you might not get along in relation to running and managing that land, but if you can't split it up, it actually goes to the person who lives longest. And that sucks. If each of you have got, say, 2 kids each, it means that 2 of those kids are going to get all of the land because their parent died last, and the rest of them get nothing. That's the way joint tenancy works. Yeah, I know, sad, eh? Because it's literally the right of survivorship. The last person living gets it all. Yeah, we don't do that. It does happen. It does, like, they can do there are all sorts of horrible things. Look, you actually can apply to the court or the Registrar of the Land Titles Act to change your joint tenancy to a tenancy in common. You can do that. And it's a pretty common thing to do when things like that come up for this exact reason, because it's really problematic. It's easy for us conceptually to just divide things up. 12 of us, divide by 12, easy. But this idea of the right of survivorship is really problematic. But it's quite common for people, husband and wife, couples that have that in terms of things through their kids. The idea is that the key thing to note is that if one of them dies, it's really, really easy in terms of succession law. You don't have to worry about who's going to get what share and have to go through and get the executor and have the family fights. It just goes to the surviving spouse. So from that perspective, it's really, really easy. So that's the one. I suppose there are some other benefits to it as well. But that's but still in the book. This is still valid law. It still happens from time to time. All right, so a couple of things to know. Co-owners, and this is co-owners is both joint tenancy and tenancy in common. And again, Jen, I'm going to use this example here. Jen with her 4 siblings having this packet of land. As co-owners, and this is important for you guys, anybody with a rental agreement, if your name is on the lease, all right, as a co-owner, you cannot exclude others who are also co-owners from entering onto the land. And if you do, because physically you can go and change the locks, right? But lawfully, you're not supposed to, and you're obliged to compensate that person that you've locked out to the extent of what they call the mesne profits. So if it's paying rent, for example, the amount of rent that they're losing out from being excluded. If it's real property that earns money, so farm, you lock somebody out of the farm, they are entitled to the profits that they would have made from being locked out. All right, that's what then that's just law, and that applies to co-owners. Co-owners include people who are on the names of a residential tenancy lease. If any of you guys are on leases at the moment. All right, co-owners cannot force each other to make additional contributions to upkeep, maintenance, or rates. All right, this is strictly true, but like a lot of areas, there's a big but here. This is really just a piece of advice for your own life. When push comes to shove, the courts do take into account contributions when property is divvied up or divided up later on. And, although I haven't put it here, I'll tell you this too. Very importantly, if you are purchasing land, the law, the state of Queensland and the Commonwealth of Australia really cares about who paid for the land. They're not quite as concerned about who paid the rates, the electricity, and the other things. Okay? It's actually different areas of law. So if for example, you and your spouse or partner, lover, whoever, decide to go and buy a house, all right, and you put it in only one of your names for whatever reason, I've just done that. The courts really care about the amount that's contributed, which is good because I paid for half. Here's the receipt. Not quite so concerned about who paid the rates afterwards, right? They are in terms of contributions, and you can go and map those things out. But in terms of the basic rights that you get in equity, they care about that initial upfront contribution. So just make note of that, guys. If you have the choice, tongue in cheek, if you do have the choice between saying, paying for the thing now or paying for the rates later, you want to be the person who pays for the house now. All right? That's just something to leave in the back of your mind. You want to be the one who can demonstrate that you've put the higher fraction of the house, particularly in situations, and I'm from Auckland, where property goes up in value a lot because the amount that you put in is actually, in equity anyway, it's the fraction matters. The percentage that you put in matters. So if the house doubles in value, your share doubles. All right, that doesn't happen with things like mortgages and paying off the rates and other day-to-day expenses. That money's just gone. Okay, so the idea is you can't force them to do it, but you can keep track of it. And later on, when the property is disposed of or there's some sort of legal rank, you can demonstrate to the court that you did make more contributions and they can take that into account. The key takeaway, always write things down. Or store all the transactional information, money information in relation to real property. The easiest way to do that, guys, of course, is use your FPOS card. At the end of the day, most of you guys are accounting students, you're good at using Excel. Something I hadn't appreciated now that the IT guys, you guys probably aware that IT as a discipline keeps getting moved between the business school and the engineering school. They keep moving backwards and forwards. At the moment, they're over there. And so the accountants are now the best users of computers in the college, which is hilarious. I'm doing support for the college. So you guys know how to use a spreadsheet. Keep your data. Don't throw it away. That's it. That's my 2 cents on that. Yeah.
I'm just asking you generally, here in Australia, the person who buys the land, who puts in the money, is more important than the person who pays later on.
Kind of, yeah. The idea is that in the area of law, so 2 things. When you're dividing things up, all right, and you're doing it either under family law, which is the Family Law Act, when you've got partners, the family will take that into account. They'll have a particular section that says who contributed what in terms of the property.
Just asking one more question. Is the source of the money who puts in important? And just asking,
yeah, it
because
is.
in India it is very, very important.
It is very important. Yeah, it is here too.
Where it comes.
Oh, really? The actual, not the person, the actual source in terms of being mortgaged or family, like.
For buying the land.
Oh wow, yeah. I'm not surprised. Yeah, it's tricky. I don't know enough about.
That person will have more right.
Yeah, they definitely.
The source is not good. The right also comes down.
Kind of. Here, the contribution amount matters and it matters in family law, and it matters in equity as well. In equity, you can use the equity principles when it's not a family relationship, two friends, for example. All right, and the idea is that in an equity situation, particularly where your name's not on the title, that amount is what's called a purchase monies trust. So it actually creates a trust across the property, and again, that goes up in value, and it can't go down. Which is really interesting. So it can go up in proportion, but it can't go down. And in family law, when doing those calculations in terms of who contributed what, this stuff was always taken into account. They always take into account purchase monies that go towards the property. Whereas the expenses are often, I paid for this, you paid for that. Because the thing is with expenses is that you've got money, but you've also got labor as well. Some people can work and contribute. And that's difficult to cost because how valuable is your time? Well, it depends. Did you take time off your job to go through and do this? In which case you could calculate it. If you didn't, you're just doing it on weekends. Well, what's the cost? And the courts have to guess. Whereas with the purchase monies, you don't have to guess. It's exactly $151,522. That's because that was the amount that you had at the time. You can track that. We'll probably take a break here, guys. Actually, my voice is a bit tired. Okay, carry on. Let's go. All right, so I just mentioned this earlier. There's one other test. This is the Skyways test, or Sky Views, I think it's called. Lord Bernstein. Yeah, but I'll go and I'll send an announcement and amend that if the timetable's there. Just make note, your exam for this subject for internal students will not have an exam listed in the exam period, because it's not. This subject is always run an exam during SWAT-VAC, the week in between the end of classes and the start of the exam period. The subject always runs. The time. Sorry, which one? The time. Yeah, it'll be the same tops. Literally here. It might not be this room, but I'll find out when I check the timetable next week. Next week. And I'll give you guys the room, obviously, ahead of time. Last year it was in room 4, building 4. They've got just a small room about this size, actually, with bean bags. Okay, just make note, land. When you own land and you get a packet of things associated with it, you get this right to quiet enjoyment, you get a right to usually get the profits of the land, the right to exclude other people into it. These are packets of rights that come with owning land. But just note that those rights don't extend all the way up to the sky and all the way down. Because in the olden rules, the olden day rules, the courts used to say, oh, when you own a packet of land, you own everything up to the heavens and to the centre of the earth. And the courts since then have narrowed that a lot at common law. And it came up in this case of Bernstein and Skyviews, where a very wealthy person in rural England had a very large property, and these Skyviews guys would get planes and they'd fly over them and take photos. And then they'd take the photos to these people and say, oh, hey, do you want to buy some photos? Here's some photos of your property. How good is that? And rather than purchasing these photos, Lord Bernstein decided to sue them, arguing that they were trespassed on their land. And then the court said, no, you actually can only, even though, yes, this old rule says, heavens, top of the heavens, center of the earth, blah, blah, blah. Essentially, it's only what you could reasonably have used. So what you could reasonably have used. And this similar thing came up with this Bocado SA and Star Energy. You can't own things under your land that you could never get to. You could never get to. In that case, it was oil. Oil that went down, and I think they drilled under their neighbour's land. Quite clever, really. Sent the straw down this way and then sent it sideways to suck the oil out from these guys. And they said, no, you only own what's under your land as far as you can reasonably use and enjoy. And so I haven't got other cases here, but for example, a scaffold or a crane that's over your property, all right? No, it's too far up. Doesn't impact on your rights. Courts don't care. All right? Whereas scaffolding that is just outside arm's reach probably would infringe upon your rights. Even though you can't reach it, you're going to suffer some form of detriment, or the land suffers some form of detriment through that being there. Yep.
In that case, if somebody is building a skyscraper,
yep.
Obviously they own the land above.
The land where they're physically putting the things in, yeah. And because when we're arguing whether they could reasonably have used, they have actually used the land. But also note with things like skyscrapers, that's actually governed by statute as well. So that there are building restrictions in terms of height to boundary, and that's carefully mapped out by parliaments everywhere. And as a result, if you want to build a skyscraper, you have to seek some very, very complex planning approvals. Very large buildings often are actually directly signed off by the parliament. So if you're going to build like a casino, for example, usually the Queensland Parliament will actually pass specific laws. It happens in places like Western Australia for mining projects. But yeah, that's how those things go. They're often, I mean, here a council would probably do it, but for very, very large projects, they're often the actual Parliament, particularly in a place like Queensland, which is not particularly big, 5 million people. It's not impossible for the Queensland Parliament to actually pass specific laws for buildings.
In a mining area, and if you own a land here,
yes,
you will be affected by the activities that is being carried out.
Absolutely, yes.
So do you have any rights?
Yes, you do. You've got a bunch of statutory rights and a bunch of common law rights. So your statutory rights are that under the environmental protection and resource legislation, under the there are things under native title, there's things under the planning rules, there's things under the Water Act, there's things under
Other than mining, in case a big construction like a skyscraper is being built and your land is attached to it.
yes you do, yeah.
And you always have a fear like if something happens.
Oh yeah, sure. Well, I mean, having a fear is, I mean, it's when we.
And if something happens.
Yeah, that's right. So okay, so a couple of things. So, in order to do a big project, to actually build a building, you have to meet planning requirements. In cities, in Queensland or in Australia generally, you can't just build whatever you want wherever you want it, even if you own the land. All right. Parliament has jumped in and said that for every building, every construction that you have to do, first thing, it has to match the character of the place you're doing it. You can't buy land out in Oak Valley and build a skyscraper. You're just not allowed to. That land has to maintain its rural character. If you want to change that, you have to go through a process of changing it, the character of the land, and you could pay a large sum of money, of course. Councils like it when people try to develop land. That's good. It lines the pockets of councils everywhere. And when doing that, you have to give others the chance to object. And the objection process can be very long-winded, and often involves community groups that come together and say, we don't want. And again, from my example, was a dog. I don't know anything about dog racing, but somebody wanted to have a dog racing thing where they breed the dogs and they have a strip where they have to practice them racing, following those little rabbits. God awful sport, but anyway, that's what they have. But as you can imagine, locals didn't want to have it. Would you want to have a dog racing place next to your house? No, they'll be like yap all the time, and you lose your sleep. And so as a result, in order for this to go through, people object, and they say that, look, as part of the design, the plan that you submit, you have to have things in there to mitigate the noise to your neighbours. You have to build a bank, it's got to be this high. It's got to be this high, you've got to have trees, you've got to have baffles, you've got to have things to stop your neighbours from being impacted or affected. That's part of the planning rules. Planning law, by the way, is actually really interesting. It's really good. Planning is a degree. You can actually do it. JCU offers it. It's an interesting and, to be honest, relatively lucrative area to get into. Anything in real estate has extra zeros after it. So as a result, it magnifies your ability to do work and earn profit. It's just the way. Yep.
You know, council used to have a motorsports area that they built years ago, way away from everything. Speedway, racing, circuit racing. And then, of course, as this town grew larger, the planners broke up area for some development all the way out around it.
Oh, okay.
And then all the homeowners got together and started complaining about the noise
Yeah.
on weekends.
Yeah. Yeah, this exact same happened in Auckland. It was the Speedway was quite close to central Auckland, Western Springs, and it was and the interesting thing is, and we talked about this under nuisance when doing tort, it does not matter if you come to the nuisance. So in other words, the fact that if you bought a house next to a speedway, it actually doesn't matter. You, as the owner of land in fee simple, have a right to quiet enjoyment and contemplation of your land.
It just, you're from the other side of the fence, it just seems like...
Yeah. Oh yeah. I know. I have that too. I've actually had this discussion many times, and that's, I agree. I completely understand, but that's not what the law is. The law is they are completely right, both at common law and in statute. Yeah.
Plans and working on building a new motorsports arena out of Ames.
Oh, okay. Well, I suppose that's quiet.
Yeah, until it gets built out of there.
Yeah, fair enough. Okay, something you'll be examined on. Fixtures. Why? It's a useful area of law to examine. Because in terms of, it's a test that you can do and you can apply. All right, guys, we can hear you. Sorry, which one? Yeah, lighting. Depriving them of lighting? Yes, yeah, you're right. So if you build a building and stop somebody getting sunlight, you bet. Yeah, it's causing nuisance. Yeah. 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 Yeah, that sounds right. That's right. And what you'll find, and you guys, again, particularly if you guys are coming from sort of developing countries where the regulatory frameworks are becoming more and more robust, things like this are going to happen more and more. And as you get older, obviously when you have grey hair, when you get no hair, you're going to find you're going to get incensed and angry because why are these people able to stop doing these things? Because we all as human beings have rights. And when we own property, we have rights associated with the owning of property. And those rights are in conflict. And the more people there are in a small space, the more of these conflicts happen. And it makes the law in relation to it much, much more complex when there are lots of people and lots of moving parts in terms of doing it. And that's why it gets harder and harder to have big projects in developed in countries where you've got these regulatory frameworks. It's really easy in countries where they don't bother with administrative law. If the party wants to build a dam, the party just moves all of the people and isn't concerned about it because it's not a culture where people have rights. But you guys come from cultures that are democratic. So as a result, it's harder to get things done. And that will become more so over time. You guys are going to find that too. And so it's just something to leave in the back of your mind. The more autocratic countries can get things done, but they do them in horrible ways because it doesn't have this aspect of rights associated with it. If you live in the place where we want a dam, we don't care. Go away. We're the party. We'll remove you. So just leave that. Which is better? No, I'm actually interested to know which is better. Which is the better society to live in? Which is the better world that you want? And sadly, it's probably the one with the whingy, complainy types. Sadly. Because if you've gone and experienced places where people have rights and where they don't have rights, guarantee you that if you go and live in one of these, assuming your material conditions are about the same, that you'll prefer the place where you actually are respected and treated as a human being and given this packet of rights. But if the material standards are vastly different, that's where things get matter. Because it turns out people don't care as much about rights when they're starving. So that's a question for moral philosophy. Not so much for land and property law about fixtures. Yep.
Just ask one question. Like in case a commercial project is being carried out,
Yeah.
started off, this is an awareness that is being done in the community in Australia.
So awareness.
Like everybody, the community knows that a project is being done, or is it done confidentially?
No. They're almost always done in public consultation. Almost all steps involved with large projects have to have community consultation, particularly if it involves government, because the government themselves have rules about what they can and can't discuss.
Community groups have rights to
Absolutely.
express it out.
Yeah, they do. And I actually teach the subject at JCU. I'm teaching it second semester where they talk about that.
I'm listening generally, is there a regulatory framework
Yes.
to help them out, especially
Yeah,
in the
you bet.
case of,
Yeah.
when you're doing new projects?
Yes, absolutely. Yeah, there is.
Not the existing project that is there and the people around it. When you're going to introduce a new thing,
Yep.
like I'm just asking, there's a new stadium that is being
Yeah.
So
All right.
the people around it, they have a say in it?
Yep,
or-
they do. And what you find is that the consultation period. All right, a couple of questions there. There's like 7 questions there. I'm going to answer a couple of them. The first one is for a massive project like the Townsville Stadium, they would just pass legislation. The Queensland government will say, look, we're not going to muck around with this. We're going to pass legislation, and it's just going to say this project can happen, and this is going to be the consultation. Look, we're not a tyrannical government. We're still going to have a consultation process, but we're going to limit it for these times. And most projects, though, that people have will have to do systems of public notification about stuff and giving people a decent length of time to comment on those, particularly to come up and say, this project is going to infringe my rights in this way, this way, this way, and this way. So people know about it. Because if they don't know that your rights are being infringed, it's really problematic. Again, going back to the example of the tower over here, if the tower goes up, then people start complaining. That's really problematic. That's a problematic thing to do. But sometimes people don't know. People don't know this thing. There was you guys, on the way to the Nathan Street Bridge about a year and a half ago, there was a huge big sign. For whatever reason, some idiots just put this massive big sign in there, this big billboard. It would look hideous right by the river. It ruined the aesthetic whatsoever. And even though the sign had been passed through council, people complained. It was just like, this is ridiculous. How could this possibly have got through? And enough people did that, and this is a very marginal political seat federally. It changed. It got taken down and chopped away and removed. All right, I'm going to carry on. All right, fixtures and chattels. A couple of things to know. The important distinction here, stuff that's attached to land, like a building, forms part of the land. It does. Guys, if you want to yap, go down the back. We can all hear you. It literally goes in the recording. If you buy a house, all right, and you rock up, you buy the house, you rock up, do the house, do the sale. Oh, yeah, this place is pretty good. If you rocked up when you got there, all right, would you expect the carpet to still be there? You would think so, and the windows, right? But you wouldn't necessarily expect the fridge to be there. Or would you? Maybe. Maybe not. Maybe. And so what this particular test involves is whether or not when you purchase or take control of somewhere, whether or not it actually has the stuff that was previously there. In other words, what stuff are you buying when you buy land? What things are attached to the land and affixed to it in such a way that they are permanent? And those things we call fixtures. There's a legal technical term. They are associated and attached and affixed to the land, and they flow with the ownership of that land to the next owner. Items of personal property that are picked up and moved are called chattels. It comes from the French word chattel, which means cattle, which is where that flowed from. So, example. Now, very important thing to note, by the way. The reason why it's good to examine, it doesn't come up in real life, is because most of the time, when you're transferring land, you do so using what instrument? Starting with C and rhyming with ontract. Yeah, that was meant to be a joke. Sorry, I'm not good at jokes. So when you have a contract, and again, I'm thinking residential property here, you'll actually have a list. It'll actually literally go through and say, these are fixtures. The dishwasher, the shed out the back, the trees, the shelves in the garage, the this and this, that. And then afterwards it'll say, these are chattels. The fridge, the microwave, the tables, the bookshelves. Right? And it'll list those things out. These rules still apply for stuff that isn't on the list. Now, real estate agents. Are there any real estate agents in the room? No? Does anybody have any family or friends that they love? Sorry. All right. Real estate agents are not renowned for their towering intellect, put it that way. So my real estate agent, when we bought this place around the corner, had tenants in it, JCU students. They were social work students, I think. They were lovely. The place was beautifully clean. And anyway, when the contract went through, me, who'd taught the rules for fixtures and chattels like 6 times, decided to be a bit of a weasel, and I just listed as all the fixtures as the fridge, the washing machine, the thing, and the other thing. Why was this going to be problematic? They belong to the tenant. And the real estate agent signed it off. I sent it back to him 8 times. 8 times, and then went back and said, he never noticed. And the other side signed the thing off. So literally, they sold the house and listed as the fixtures, washing machine, the fridge, and the other whiteware, dryer, something else. There was a bunch of things anyway. And I sort of said to my, now ex-partner, I said, I could be a bit of a dick here and actually go back to them and say, where's the fridge? It's here, it's listed in the contract. Because the other side signed it off. And they're like, I'm sure the real estate would have said, oh, no, that was the tenants. They're like, well, that's nice that it was the tenants. This is a contract. I didn't, but, there was probably $1,000 worth of that in terms of them just being silly. And look, I wouldn't have felt so bad other than I had to correct the contract 8 times, going backwards and forwards. Real estate agents, sorry, Shad. Real estate agents are they can be a little bit dopey. So just be careful. Look, you guys, at some stage in life, you're going to be associated with the transfer of real property. Read through it carefully, go through this list, and cross-check it. Are the things in these 2 lists, the fixtures, the things that are going to stay, chattels that are going to go, do they actually align with the real world? And if they don't, the stuff If you guys are going to be accountants, you work it out. What's it worth to them in order to keep things or to take things away? Sometimes, by the way, you don't want stuff. You actually want them to take a whole bunch of stuff away. That can happen too. All right, key things to note. This is a test. It's a bog standard legal test that we use. It'll be in your exam. And it goes like this. There's 3 things they look at when trying to determine whether a particular object is a fixture as opposed to a chattel. The first one is what we call the objective intention test. That's the same as in contract law, where a reasonable third party looks in what would both of the parties have actually thought if they'd contemplated this. That's the first one. The second one is the purpose of annexation. What is the fundamental design or nature of the thing or object that we're talking about here? Is it something that was fundamentally designed to affix to the land and not be removed? Or is it something in its essence or its very nature is designed to be picked up as an item of personal property and removed and taken somewhere else? All right, that's the second test, the purpose of annexation. And the third is the degree. How stuck is that thing to the ground? Is it affixed just by sitting on its own weight? And if it is it really, really heavy? Is it bolted in place? And is going to remove it going to cause a lot of damage, actually harm the land in some way? And so, as an example, looking around the room here, that whiteboard, objective intentions of all parties. Well, I'm trying to think if this room ever got sold, but let's just say it got sold to some other university. Now, they've split JCU in 2 at the river. Yeah, that's right. The other half goes to stays with JCU. This half gets sold to CQU, whatever like that. And they're working out this room, working out what stuff is here. Would a reasonable person look at that and think that was something to be picked up and taken away? Probably. Probably, you guys reckon? I reckon it probably would. Something a little trickier. What about this whiteboard? Would a reasonable person think that that is meant to be picked up and taken? Well, it's got wheels, so probably. And then we think of this thing here. Now, this thing in theory is actually movable. I think I've done it sometimes. So it's bolted down like that. In the other tube rooms, these things move. Oh no, it does move. Okay, it's sitting on its own weight. All right. Would a reasonable person think that that is something that's picked up and taken away with, when JCU has to go over that side of the river or not? Probably not. Maybe. I don't know. It can be a little bit tricky to determine that one. So then you look at the second test. By the way, in your exam, for each item, use all 3 tests. Literally, it's just easy marks. It is just the easiest marks you'll get in your entire exam. The purpose. What is the purpose of that whiteboard? Well, another example, by the way, is the carpet. The objective intention of the parties in relation to the carpet is for it to stay. And that's a pretty unreasonable thing that we're going to go. If it was a rug, maybe different, but this is carpet. All right. Purpose of annexation. That whiteboard isn't really annexed at all. By its nature, it's designed really to be picked up and moved. This, probably the same thing, although if it was big and really heavy, maybe. Or if it was designed in some way to sit there. So I'm trying to think of an example of something that's been custom done. The carpet's a good example there. The carpet, by its very nature, is designed to form part of the aesthetic. But its fundamental purpose is to stay with the building. It's been chopped and customized and cut out in order to do that. And the same probably with this little thing here. It's been purchased specifically to sit in that particular corner and integrate with the rest of the stuff. By its nature, it ought to be attached to the land or affixed to the land. It can be considered a fixture and travel with it to the new owners. Not travel. Title would pass to the new landowner in that case. All right. Third test, the degree. How stuck is that thing? Not at all. How stuck is that? Not very much. It's got wheels. The degree of injury, removing that, in fact, it's a bit of an eyesore. Probably helped the land in some way. This, getting rid of this, it's going to create a hole because the carpet will be a different color. You'd have to pull all the cords out and make a big mess. All right, so these are things you take into account. And the carpet, if you ripped it out, is going to make a huge mess. It's going to make a massive amount of damage. It'll damage not just the land, but also itself when you're pulling it out, ripping the carpet out. All right. That is how those tests work. It's literally that simple. and it is an easy 4 marks. It's quite a lot relative to the difficulty of those things. But just make note, law exams, because they're open book, they're a little long. Be prepared to write. And sadly, you have to write the test for each item. So I'll probably give you 4 or 5 items. You have to describe that test for each of them. Describe the test at the start. You explain what the purpose, explain the objective intention, you explain the degree test, and then you apply each of those 3 to each of the 4 or 5 items that are listed. If there's carpet, talk about the carpet in relation to all 3 of those tests. And conclude, because strictly speaking, the objective intention test is the most important. But if it's only, you really only use the other ones if you can't guess what the objective intention of the parties would be. So probably something like that. Difficult to tell. Yeah.
It's difficult to move. That's what you're saying.
So it's difficult. It's difficult for us as a third party. There are 12 people in this room. Would we agree or disagree, or would we probably be split? If 12 people in a jury would be split in terms of thinking what the objective intention of that is, then it's not going to work well as a test. So you'd use the other ones.
What do you mean by saying objective intention?
The objective intention.
Is the objective intention of the party who used it?
No,
Or the party who's going to use it?
of the party when it was put in there, and when you're determining whether or not it's going to flow to the person who's keeping the land. Would the parties, when the thing is when this thing's put into place, have thought that it was designed to form part of the land and stay with the land?
Imagine you can open it,
Yeah.
unfold it.
Yep. Yep.
Then there's no issues in removing it.
Well, it's an objective test, remember. It's what would a reasonable person think, not whether you can actually physically do it or not. It's the and it's actually separate and distinct as a test from how attached it is and how much damage it would do and what its purpose is. It's what would the parties reasonably have thought. Now, we know what the parties actually thought or would have, because what they actually thought is enshrined in the contract. But we have to assume that the parties didn't think about this. So we're trying to think about this. You've got 2 reasonable abstract individuals. One's buying land from another one, right? And they both forgot to write whether this is a fixture or a chattel on the form. All right? So the court has to jump in and say, what would 2 reasonable people have thought? That's the objective intention test. Sometimes it's really hard. You're just like, oh, I don't know. A reasonable person might say this or might say that. And in a court case, you'd argue one way or the other. Just one side would be arguing, a reasonable person would definitely think that it would stay with the land. Clearly, for the purchaser, you'd say that. If you were the seller, you'd clearly say, a reasonable person definitely would have thought it would be picked up and removed. So that it's to do with the argument that you'd make in each of those cases. I'm not helping you much here, am I? But just think of it into the absence of the 2 parties actually agreeing. All right, we have to think about what would a reasonable person in each of their positions have actually done and decided upon. That's really what it is.
The Australian context is different. That is why I was asking. If it was India, we would take it and go. That comes with.
I grew up in South Auckland. Yeah. There's a bit of snatch and grab. That's the way that works. Yeah. It's Oh no, I've got more slides. This slide actually just essentially just repeats what I've just said. So there we go. It repeats what I've just said, literally, with some cases, which I suggest you cite, by the way, in the exam. Just put the cases in. This is like, guys, it's seriously, this is, if you are willing to just accept these tests exist, you can regurgitate those tests, explain them in the exam, and apply them to each of the 4 or 5 items, and you'll just get maximum marks. You literally will just get, I think it's 4. Oh, in fact, I can tell you. No, you only explain the rules once. You explain the rules once. So yes, in the exam, yeah, something like that. You probably write it in your own words, but yeah, you would write each of those things. That sentence to explain it. That sentence or couple of sentences to explain the first test. Couple of sentences to explain the second test. Couple of sentences to explain the third test. Cases for each of them. Then apply it. And to be honest, doing this part that you can prepare in advance because it's an open book exam is going to be worth like 1.5 of the 4 marks, literally preparing those 3 statements of law. It's an open book exam. I know it's real tricky to get your heads around the idea that you can literally score like 20 to 30% of the exam by just regurgitating rules. It's real scary. That's just the way law exams work. I don't think it's a great plan, but that's just the way it is. So it's a useful thing to remember. If you're prepped and ready to go for the exam, you can prepare a whole bunch of stuff. But you can't get full marks or even a pass mark if you're not applying it. So if you write these things out and just regurgitate it, and then you go to apply them, and I'm reading, and you have no idea what's going on here. You're still going to get the marks for explaining the rules, but you won't get many marks for the application step. You have to demonstrate to me, or the person marking it, that you've understood those rules when you're applying them to the facts. So for example here, if you'd written these things out, something similar to this, and then you're talking about things, and one of them was carpet, and you say, come up with something like, oh, the objective intention of the parties with the carpet was for it to be a chattel. You're going to get it wrong. Parties almost never would expect carpet. Objectively, a reasonable person would not expect carpet to go and be picked up and used as a chattel. All right? That's just flat out wrong. Certainly wrong with the other 2 tests as well. But even if you tried to make an argument in the reasonable person, you're just going to get that wrong. You could make an argument if something, for example, was detachable. A rug, a custom rug that matched the colouring of the place. You could make an argument either way for that, because the objective intention of the parties might be that this rug which matches the colour scheme, a reasonable person might have thought that was supposed to form part of this theme. And there was a case, I don't think I put it down here. No, I have not. There was a room styled the Elizabethan room. And the argument was whether some tapestries of Queen Elizabeth I were supposed to stay with that room, even though they could easily be picked up off the wall. They're paintings or tapestries. They just be picked up and removed. There the court said, no, this was the Elizabethan themed room. Therefore, by their very nature and design and purpose, they were to be considered fixtures. All right, so those things you can make an argument either way. All right, what are we, 8 o'clock? All right, we're just going to carry on. Is that all right, guys? We've got a few slides still to go. Okay. Oops, no, wrong button. This button. All right, I've used these terms. All right, here we go. Chosen possession and a chosen action. I have no idea where these phrases come from. It's just legalese. I don't think I use these in the exam. So just make note that I don't use these things in the exam, but they probably won't ever come up in your life, I wouldn't think. The terms that lawyers use, in my notes, I don't even know why I even teach this, but when we're describing things that are rights associated with tangible stuff, we call them choses in possession. So that is the legal phrase for describing the right to possession for a certain thing. And a chosen action is what we use to describe the rights flowing from intangible stuff, intellectual property and so on. But I've got some examples here. So, example of these. Choses in possession, because not everything's capable of being owned. That's really the key thing here. Not all tangible things in the world can be owned. So here's an example. Things that can be owned, goods, physical money, capital equipment, ships, pets. Pets, by the way, your pet, anybody have a pet? Cat, dog, pigeon, guinea pig, snake, anything? It's Queensland, you're allowed to have a snake. I think you have to have a license if it's a certain type. I think poisonous snakes need licenses. I don't know about you guys. I'm from New Zealand. There's no snakes in New Zealand. My Kiwi friends and me we're terrified of snakes. And I thought I'd move to North Queensland, there'd be snakes everywhere. Nah, I've seen like 3. And they're quite cute. I've been here too long. Emblements, things that are crops from land, so things that are grown on land, are choses in possession. They're things that are capable of being owned. Tangible things capable of being owned. There are, however, tangible things that are not choses in possession. Emblements is stuff like crops on lands, crops or fruit or things that is on land, but it's been cultivated in some way, or it is capable of being cultivated. all right, and it's controlled in some way. And the reason why I say that it has this control thing is because wild animals are not considered choses in possession. Wild animals are not capable of being owned until what happens? Yeah, until you take them. You literally take the things. You get the snake and you bring it home and you show it to your mum and say, "Mum, I don't want a cat, I want a python." At that point, it becomes yours. You've mixed, the philosopher John Locke, you mix your labour with the land. It's now your thing. You've taken it. The nastier way of saying it, usually when I say it with this class, people don't say it's when they take it. Usually they say it's when you shoot it. If you go and you kill something, a wild animal turns into a thing capable of being owned. All right. Tangible things, they're not chosen possession. Land and buildings. Why? Because we use different rules for those. They're not personal property. They're just considered real property. Human beings cannot be owned. Slavery hasn't been cool for a very long time. Also, interestingly though, human tissue, your blood, you cannot own your blood. There you go. If you take a litre of blood out, you don't own it. All right, so that is the law in the state of Queensland and the Commonwealth of Australia. It is different in different nations. You can own your blood and your tissue in other places, but strictly speaking, it is not capable in our legal system of being recognised as something capable of being owned. It's not a chose in possession. There is an exception. Yep.
You mean to say that you can't sell it?
You cannot. Well, the statutory frameworks will let you override that, but you can't sell your. Yeah, things like, well, the example is hair is actually the example. I've got female friends that have had beautiful hair, and they have gone and sold it. And they're just about to explain there is actually one exception to that. It's a long-standing exception. In the case of Doddywood and Spence, it involves the work and skill exception. Parts of your body that you chop off and process in some way. So if you take, for example, if you chopped off, there's a bit more, but if you chopped off your finger and preserved it in formaldehyde, all right, that would become a thing that's had some work or skill associated with it and is capable of being owned. If you chop your hair off and create a wig out of it, that is something which is capable of being owned. And at common law, that actually provides an exception to that particular rule. An example said Doddywood and Spence involved I think an aborted or dead fetus of a Siamese twin. All right, so from the 1800s. Right, this case was from 1906. The idea was that it had died in like the 1850s and been preserved in formaldehyde, so a two-headed fetus, yay big, in a jar. And the court, somebody found it, a pious person, and wanted to give it a good religious burial. And the person saw it, wanted it, and went to court, went to the High Court. And there the court actually said, no, this is an exception. Things that have this work and skill applied to them will be capable of being owned. There you go. It's a bit of an obscure thing. Probably won't come much. I hope this never comes up in your business careers. But anyway, that's the way our property law works. Airspace. I think I mentioned before, you can own land, and you can own land, but you can reasonably use above your land. But you don't own the stuff way up there. And the same with waterways as well. You don't own those. You can't. They're not capable of being owned. They're not chosen possession. Yep.
Answer the question. Can you sell it?
What? Your blood?
No.
No. Well, there's there could be a statutory framework that lets you do it if you've got a rare blood type, but classically in Australia and New Zealand, you can donate blood. You can't sell it. And look, there's no, definitely not. Definitely not. Without any, absolutely not. You can actually donate. You can't sell them. You can donate. You can't sell. That's just wrong. There's a very strong policy reason for that. Yeah. Yeah, I know. Well, you hear these horrible stories about these Pakistani farmers selling kidneys. This is horrible, and that is something that is just completely.
It happens in hospitals too. Unaware, or the patients are unaware, and still it's gone.
Yeah, I know. You do hear stories like those, horror stories like that, and I mean it does happen. People, and again, it's this horrible world we live in. We go from wealthy countries. People go from wealthy countries and want a kidney transplant because you're on a waiting list. You can only have one when it's donated, usually when somebody dies, and that's extremely problematic. Yeah, yeah, it's not much fun, this area. Like, then this is the sort of area of law. It's interesting. This is the cocktail party sort of discussion. You find that completely unrelated, by the way, to pretty much anything you get in professional practice. But it's interesting. I mean, what's the point of being alive if you're not learning, stretching your minds a little bit and thinking about stuff? But anyway, other things that's not a chosen position are check. Check. You guys know what checks are. We'll talk about them in week 12, I think. Checks is an order or an instruction for a bank to pay money from your account to some person who cashes that check or banks that check. And wild animals can't be possessed. All right, that's the first one. All right. Chose is in action. Now, accounting students, I'm really sorry about this. The word intangibles in law has a slightly different meaning to what it does in accounting. I'm so sorry. There's a bunch of times this comes up. Equity is the other one as well. Because when dumb lawyers think about intangibles, they are also thinking about things that just can't be seen, like debt. And debt, from our perspective as accountants, is not an intangible. The debt is just a debt. It's an amount on your balance sheet. It doesn't go in the intangible section. It goes in your current assets or your long-term assets if it's a long-term debt. That's a straightforward, important, regular, normal transaction or account, I suppose, that we have as accountants. But sadly, the lawyers, and look, you guys, to be honest, look, I'm taking the piss out of lawyers a little bit, but you guys have to be aware of this because you're going to be dealing with these people. They're going to know more. You guys are going to know more about your organization in terms of value, in terms of the bookkeeping, in terms of the accounting aspect of it. They're going to know more about the underlying legal rules and principles, this stuff, but in more depth. And so you have to be really careful that you're speaking the same language in relation to these stuff, and just be mindful that that sometimes you can be at cross purposes. And so when they're talking about intangibles, it means all of these things. Whereas we as accountants certainly not. Certainly not. All right, so these things, when they talk about legal chosen actions and intangibles, they mean a whole bunch of stuff that we would not consider to be intangible. Bank account is asking an accountant. Bank account is not intangible in accounting. It is in law, because it's something that's not physical. It's a virtual thing. You don't see it. If you think about it, and you can see why. From that perspective, if law students, not the most brilliant of types, they can't see it, therefore it's not something physically capable of being grabbed, possessed, and owned. Shares in companies, yep, copyrights, patents, designs, legal charges and security across assets, trademarks, business names, goodwill, reputation, bear rights to sue and tort. Your rights to sue can be assigned. They are of value. If they can be transferred to others, you can give them a dollar value. And what is the exact dollar value that they're worth? The amount that you sold them for. It's an easy way of valuing them. All right. Now those are legal chosen actions. Now I've talked about equity a little bit. Equity are things that aren't recognized in the common law. They're only provide some form of remedy where the regular laws, parliaments, so statute and common law rules break down. You can have these rights in equity. And one of the frustrating ones, have I got here? Future income. Very easy for us as accountants to conceptualize and often calculate future cash flows. It's easy. It's a trivial component. You put it in Excel. Future cash flows, discounted, and so on. Lawyers are not quite so good at that. And one of the reasons is that they're not allowed to. The common law, you can't actually recognize future property. You can't transfer future property at common law. You can only do it in equity. And that can have some far-reaching consequences in terms of doing it because other principles of equity apply. Remember what I talk about? You can only go to the courts of equity with clean hands and you can't take too long. And there's a whole bunch of things. And the most important one to note, though, is that equity is discretionary. The judge you are asking something for in equity can just turn around and say, no, you haven't fulfilled all these other requirements and principles in relation to this, therefore you're not going to be able to get this remedy. And that can be a bit problematic as well. Rights to a partnership. Remember, partnerships are not legal entities. They're accounting entities, but they're not legal entities. It's just all of the people operating together, coming together to operate a business in common. So if you want to sell your share, that doesn't actually exist. It's not like shares in a company, which you can transfer because you can calculate, and it's done under a statutory framework. You can transfer those. It's not like a tenancy in common in property. Remember, I talked about real property, 12 of us in the room, we put in $100,000 each, want to transfer it, we can just sell that share. That's fine. You can't do that for partnerships. At common law, you can do it in equity, and it requires consideration, intention, and writing. Property Law Act says you can do it, map it out, but judges still have discretion over those things. It can be a little bit dangerous. Yeah.
So partnership does not have a legal
Nope.
existence?
That's right. Absolutely not.
No legal framework to govern partnership.
Oh no, there's a legal framework in terms of the common law.
There's no registration.
No, strictly speaking, so you actually don't need a deed. In fact, I've had this exact argument because it turns out in the Property Law Act, when you go through a separation, says you must show the partnership deed, but a partnership deed is actually not a requirement. So myself and my ex-life partner have a business partnership with no deed, and her lawyers keep saying, "Where's the deed? Where's the deed? Shows me the rules. Where's the deed?" I'm like, no, it's a partnership under the general law. I literally can get the guy who wrote the textbook, he's my PhD supervisor, to explain that to you if you like. But strictly speaking, you don't need one. But partnership law is still governed by the common law and equity and statute, right? And partnerships are essentially, because they're not legal entities, they're just the collection of all of the people in the partnership operating individually and binding all of the other members of the partnership. So you owe a fiduciary duty. Remember I talked about fiduciary duties last week, the week before? Very strong duty to all of the other partners to put their interests ahead of your own. And all of them must do that. Now you can imagine with partnerships, when you start to go beyond 1, 2, 3, 4 partners, or when you've got dozens of them, you can see how things would break down because your systems of governance start to break down because each person must know and be responsible to each other person. And as the permutations go up, your brain just can't handle it. And that's why partnerships only really work for small, possibly even medium entities, but only usually small ones. And they've been retained in professions where Parliament has said, we don't want lawyers to have companies because shonky lawyers will create companies, trade recklessly by giving bad advice, and if they lose out, they just go broke. And the company disappears and the lawyer gets to walk away scot-free. We don't want that. We want them to actually have stronger duties than that. Accountants used to have it. I think in Queensland, accountants don't need to be partnerships anymore. I think it changed. When I was a young lad studying accounting in my first degree, accountants did have to be partners in New Zealand anyway, partnerships. They couldn't be companies. All right, and trust as well. Last week I talked about trusts. The rights of beneficiaries to get the good bits, that's only in equity, and assigning those, you can only do under specific statutory provisions of the Property Law Act that say you can assign things in equity only if you do this, 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 and this. All right. Okay. Ownership. What does it mean? All right. Now this actually goes back, I think, to the first slide when I was talking about ownership in the courts in Yana and Eton. We're talking about what is ownership? What does it actually mean? So if I own something, what can I do with it? Well, I can use it. I can have a right to take possession of it. I have a right to rent personal property. I have a right to lease real property. I have a right to mortgage my property, to seek some form of loan with using the property, the land, real property or personal property as security. I have the right to destroy my own property. All right, and this is something that it's actually not all legal systems have this. If you go back to some old legal systems, people don't, strictly speaking, in all systems, have the right to destroy all forms of property. And you can kind of see why. If you went back thousands of years, somebody owned family goat, and there were no other goats, and they just decided they'd destroy it. That's a real bad thing. It's a real bad thing for people to be able to do that. And I'll talk about Parliament soon, actually. All right, you can assign things. Assign is to basically give, either through contract or through gift, rights to something to another person. And you can do that for personal property and for intangibles as well. There are some restrictions on some things. There you go, rights. So there you go. Cars, motor vehicles. Can you sell your car to whoever you like, whenever you like? No. Car has to have registration. in order to transfer it from the state of Queensland. It's actually not strictly true. You can actually sell stuff at common law. Just can't. They have to go through and re-register it. But if you want to sell a registered car to somebody, the registration has to pass through. That's a restriction in some way on your pure right to alienate your vehicle. Heritage listed buildings. If you own a building, it's heritage listing. You can't just destroy it and trash it and knock it down. Council and the Queensland Parliament says no. And life tenants. If you have, as the person who owns a land in fee simple, the greatest grant that you can have, if you decide to grant a life tenancy to your mum or whoever, there is actually a common law rule that says that the life tenant can't destroy the property. They actually still owe a duty back to the person who created the grant in the first place. They call it wasting. All right, not going to worry about that. Possession and finder's rights. Oddly, this is actually in your exam. Oddly. Oh, I say oddly because it's not really that important. All right. There is a difference between possession and ownership. You need to know that difference. Possession is having or be able to exert control over it. It actually comes from the common law. Have I got the case? No, I haven't got the case here. The case is he corte. Not relevant here, but it's interesting because I use it as an example of a word which is not defined in a statute. It's defined in the common law. The idea is you possess something when you are able to exert control over it. Possession has a mental element to it. You can't possess things you don't know about. All right, so you have to actually have some aspect of intent in order to do it. What do I say about that? If somebody slips drugs into your pocket, you cannot be found guilty of possession. Now, there is an onus reversal. You actually have to prove that you didn't those things if the drugs are found on you. But strictly speaking, it must be demonstrated that you have some form of knowledge aspect over it. But it doesn't mean that you have to have the thing within arm's reach. So I, for example, possess this because I hold it in my hand. It's pretty straightforward. I'm considered to possess it when I've got it there. I actually also possess it if it's in my office level 1. Right? It's deemed to be in my possession. That's just the way we define this word. Okay? It's a common law test. It comes from the drug cases, by the way. That's why. But they use the same word for all of these things. But key thing to note is that possession is not the same as ownership. If I pick up this chair, I'm in possession of this chair. Do I own it? Do I own it? No. James Cook University owns this chair, even though I'm the possessor of it at this moment in time. And very interesting thing about our legal system is that, and I love this phrase, possession is 9/10 of the law. What does that mean? A person possessing something has the best rights other than that of the true owner. So you need to kind of think about it. This is actually more a practical solution for things. If you can't find who the true owner is of something, all right, who's the best person to have it? That's the person who is in possession of it. That's the way that works. Armory in Delamere involved a chimney sweep that found a ring in a chimney. Right, the ring, gave it to the jewelers for them to inspect it. All right, and then they demanded it back. Well, I think when they'd gone to get it back, they'd swapped the stones over, and the person who the chimney sweep went to sue, and the jewelers said, "Well, no, we were in possession. We had the best rights," but the jewelers lost. And there, the court said that the true owner couldn't be found. Therefore, the person who did find it first becomes the true owner in that situation. And again, if it had been a situation where both sides had found it at the same time, the one who did the finding or was in possession of it at that time would step into the shoes of the true owner. The true owner could not be found. All right, a couple of things to note. If you find something as an employee, it belongs to your employer. You have fiduciary duty to account for all property that you find during the scope of your employment. Burn and Hoare was a Queensland case involving a police officer finding money, I think, while in a movie theatre. And the movie theatre, I don't think they were on duty. I think the police officers had been asked to go and for a movie theatre in Mount Isa, whatever, I don't know, drive-through movie theatre. And in the scope of doing that, had found some money. And and there the courts actually said that normally a police officer walking the beat, finds some money, belongs to the Queensland Police Service. All right. In this particular case, because they were doing this and they were kind of outside of their hours, even though they were still acting as policemen, they were outside their normal hours, therefore not in scope of employment, therefore it belonged to the cops that found it. In Parker, in British Airways board, a guy went into one of those like Qantas lounge type places and found a gold bracelet, handed it in to the airport guys, and said, if nobody comes to get it, can I have it? And they're like, whatever. And then a month goes by, he calls them up, what happened to the gold bracelet? And they're like, oh, we found it in our lounge. It's ours. It's our space. It's our bracelet. And went to court, and he won. And they said, no, the person who finds it has the best of, provided it's an open space and not actively being controlled. If, for example, if the guy had found it at the Qantas, at the counter, for example, where all the staff were standing, and I found it here, probably not. But in the lounge, so for example, this room here, if one of us found a gold bracelet on the floor under Jean's feet, we're at the moment of going through and controlling this space, right? If the same thing had happened, if I'd wandered in at midnight, as I'm often here at midnight, if I'd wandered in, seen the gold bracelet, picked it up, no one's controlling it, I would have the best right. I'd have finder's rights in that situation. All right. You can find things that are attached or affixed to land. And again, things that are found, you find something in or on the land that's not buried too deep. You, as the finder, get the best right. If it is affixed or attached to the landowner is going to get that right, even if you're the ones that found it. Yules and Briggs gas involved a boat, an ancient, like a Viking boat that was that some guy had found, and the gas company wanted to claim it because it was on their land. And there, the court said no, it was so affixed to the land it actually belongs to the owners of the land. Whereas the South Staffordshire Water Co. in Sharman was a ring that was at the bottom of a pool and was able to be pulled out. Therefore, the person who found the ring got that. Anyway, that will probably be in your exam. Again, they're pretty simple rules. You do have to sort of know those. I think it's not very many marks either. But bailment. All right, bailment. Bailment is different and separate from contract and separate from tort. And it involves where one person has possession of another person's stuff, tangible properties. All right, it can happen both voluntarily and involuntarily. You can be a voluntary bailee. Bailee is the person who takes possession. The bailor is the person who gives the thing away. You can do it voluntarily. I choose to carry Jean's bag to the car. All right, while I'm doing this, I'm going to the car. Now, you can be a bailee of reward. What does that mean? It means there's a contract. You're getting paid to do it. Even it doesn't strictly need to be a contract. You pay a family member, for example. But usually in situations like that, it is a contract. So an example of that is a transport company. Transport company is a bailor. They are taking your stuff and moving it somewhere. Furniture removal, picking your stuff up and moving it somewhere. And they're doing it for money. But you could rent a truck and move your family's house. Go move your friends and get a truck and do that. And so do you still have duties to look after their stuff at law? Yeah, you do. But it's under this area of law. It's a much lower bar than contract and in tort. All right. And so here you go. Your common law duties. The bailee has duties to take reasonable care, retain possession of them, not make unauthorized use of them, and return them. I mean, these seem really commonsensical rules, aren't they? They are. But common sense and legal rules, sometimes they're in alignment. Not always, though. The bailor, the person giving the thing, has the duty to actually give them the thing. Otherwise, again, if you've got a contractual relationship to move some goods, you don't give them the goods, it kind of defeats the whole point of the thing. But not to interfere with them. Once you've given them to somebody, you have a duty to not interfere with them while they're doing their task as the person doing the thing with the stuff. Because this is going to arise in a whole variety of situations. Somebody's moving a stuff from somewhere. Somebody's holding on to your goods for a period of time. You've parked your car in a car park, a paid car park or an unpaid car park. The theory the person who owns that land has got your car for a period of time. The tow truck drivers that come to those car parks and tow your car away, they have your car for a period of time. They become bailees of your vehicle. You have to tell the bailey if the goods are dangerous, and ensure the things that are hired are merchantable and fit for purpose. So if you're actually having a situation where a person is hiring something, there's an old common law duty that says you can't give somebody something that they're supposed to be using for a particular purpose of hireage. And again, that's paying or giving some form of reward. It doesn't strictly have to be a contract. Those goods have to be fit for that particular purpose that they're actually being used for, and merchantable. So if the thing is to be used in a certain way, if I have an agreement with my brother to borrow his car to take to some friends on a paid tour around Auckland, all right? My brother, he has a bunch of cars. He has a car hire business, so I want to borrow one of his cars. Oh yeah, I'll give you a box of beer. Not a contract. He's my brother. Remember, probably not going to be a contract. I'll give you a box of beer, maybe. We'll drink some beer together. So there's some sort of reward involved here. I'm hiring the vehicles for that time, but he actually has a duty, a common law, and a bailment to make sure those goods are of merchantable and fit for a particular purpose. The key thing to know, the car would have to be registered and safe and not filthy. So he would actually have a duty under this area of law to do that. Again, am I likely to sue my brother? Probably not. But that's the way. That's just what I'm just telling you what the laws are. Standard of care is an objective test. It's a reasonable person test. And look, reasonable person in regards to looking after stuff is really low. It's a pretty low bar. Because we don't like imposing duties on people. We just say, look, if you're taking something from somebody, borrowing it, taking it, using it for a bit, you've got to take reasonable care of that thing. But you don't have to take very, very high precautions. For example, you don't have to insure a vehicle, for example. Borrowing a vehicle from a friend, you've got to take reasonable care of it. If you don't, you fall below that standard of what a reasonable person would do, and some damage is going to happen, then yes, they can sue you. This is the area of law they sue you under when looking after your stuff. And it may have, okay, this is not, it might come up in your business career. It probably will, actually. People do, for whatever reason, end up with other people's stuff from time to time. It just happens. You end up with somebody's stuff. And so you do have to make note that in terms of this level of care you have, if you're doing it for no money, all right, if I'm looking after my brother's car or cat, remember, pets are items of personal property. If I'm looking after these things, the standard of care is pretty low if I'm not getting paid. It's higher if I'm getting paid, and it's higher again if I'm in the business of being paid for doing this. So a transport company is in the business of picking goods up and doing stuff. Furniture removal have a higher standard of care at law. So we're trying to work out what a reasonable person is, what a reasonable furniture removalist would do in terms of the care they take. All right.
If a warranty person is doing.
Oh, sorry, which one? What?
Helping out in
Yeah.
payment.
Yeah.
Helping out in transporting.
Yeah, yeah.
Any services or looking after the pet voluntarily. Do they have a lower charge?
Yeah. If you're doing things, if you're not getting paid, you have a low standard of care. What would a reasonable person moving furniture for their friends have to do? Don't throw the thing off the edge of the house. But if you are moving it and you slip and you drop it, you've taken reasonable care. You just slipped and dropped it. So that's one thing. Look, it does. I don't know about you guys. In your 20s, I don't know about. I'm not sure. Again, I don't know because it might be a very cultural thing. I'm not sure. I'd have friends who would move house all the bloody time. And they'd always call me up and say, "Oh, can you help us come and move house?" And they'd have so much stuff, and I'd go shopping. I don't know whether it's the case here in other countries, but in New Zealand anyway, girls do better at school, secondary school, than boys. And so by the time you reach the end of secondary school, there are just the girls outnumber the guys by 2 or 3 to 1. It's awesome. And we have 13 years of school, so we're actually a year older when we head to university. So as a result, by the time we finish school, 2/3 of my friends were female. And one thing I found when going furniture shopping with them, I go with particularly my friend Jo. Jo, if you ever hear this, I love you to bits, really. She'd say, "Oh, Simon, what do you think of this?" I'm like, "I don't like it." I'm going furniture shopping. "What do you think of this?" "No, I don't really like it." "And what do you think of this little thing down here?" "Oh, yeah, I love that. You should buy that." "Oh, why that and not this and this?" "Well, because next time you go furniture shopping, you're going to call me up and I would rather be moving this than either of those two big things. And this is literally, yeah, she's like, oh yeah, actually I do that. I know, yeah, that's a little mean. But yeah, and you'll also learn too, for those that move around a lot, stuff can be, it's really annoying if you have to pick it up and move it many times.
In case there's an injury happening.
Oh, there is that too. Yeah, injury. It's more injury that can happen to friendships when you're moving, and they've moved 5 times in 13 months. Yeah, that can be problematic. Have you guys heard of Marie Kondo? Yeah, anybody else heard of Marie Kondo? She's super famous. She is the world expert on tidying. She's a little Japanese lady who doesn't speak English very well. And she is, look it up, Marie, M-E-R-I-E, Kondo, K-O-N-D-O. It's this whole phenomenon. This is just amazing. You guys, it's just amazing. It's a global phenomenon about this idea of having stuff. And stuff is, fundamentally, over the course of life, is bad for us. It's something that I found it really kind of ironic that in Western culture, they've started to move sort of full circle towards, this accumulation of stuff in the, 17th, 18th, 19th, 20th century. And they've gone full circle to almost the Dharmic type style of trying to not have stuff. Yeah, it's gone full circle. And I find it kind of hilarious with my friends in the subcontinent at the point now where they're starting to get wealthier and wealthier and want more stuff. And I'm like, no, that's not what the Buddha, that's what Gautama said. Anyway, but Marie Kondo is famous for having all these TV shows and made like tens of millions of dollars through showing people how to make their lives easier by throwing things away. It's really quite sweet. She'll have a little Japanese ceremony where she'll sit down and light a candle or whatever do, and then she'll get people to pick their things up and say, think about the memory, right? Think about what this meant to you, treasure that memory forever, and then let it go. It's quite sweet. If it makes you happy, yeah, it's kind of filled with joy or something like that. It's real funny. So that's Marie Kondo. Yeah, you guys can Google her. She won't be in the exam. Sorry, maybe next year. All right, variation, common liability for bailment, modified contract. Yeah, contracts can vary bailment. It just can. So you can have contracts, but strictly speaking, it doesn't actually need to be a contract. You can just have an agreement, particularly where things aren't supported by consideration. So that, yes, you will do this, but we're not going to do that. All right, we're going to take control of this thing. We're going to give you this thing. All right, and you're going to agree to do this particular thing to it. But if there's, even in the absence of no contract, that will still modify the rules for bailment. You can actually go and change that liability, usually to reduce it, not to increase it. Almost done. A lien. It's a funny spelled word, this one. A lien, common law lien, is, look, this actually does come up in business. Again, usually these things come up in contract. You go to the mechanics, they'll have a little thing that you sign that says, if you don't pay, you don't get your car back. All right? They can do that. They're allowed to do that in contracts. But they get this right at common law to do it anyway. And the idea is that if you're doing some work on a chattel, helicopter, car, whatever like that, or doing some work on someone's financial accountants, doing some work on some financial accounts and they haven't paid their bill, what are you going to do? Withhold them until they pay their bill. All right, that's you can retain possession of stuff till it's been paid for. That's just a lien that you can have. It's a right that you can have at common law. All right, but at common law also you can't sell that thing. The mechanic can hold on to your car for as long as they like, but at common law they can't sell it. These are often modified by statute, and I'll talk about the innkeeper's one next. All right, there you go. General lien entitles the holder retain possession until all debt owed by the owner are paid. But that is only a common law for that exhaustive list of professionals. Lawyers, yeah, we get it, yeah. We get to keep as much as we like. Bankers, you don't really get private bankers because the way the banking law works in Australia is you have to have, yep.
Just asking the financial data, how are you going to have a right on it? It's not tangible.
Yeah, put it on a USB stick, print it out. Yeah, you can do it. It's just usually these things are governed by contract anyway. You pay your bill, you get your tax stuff. It's tricky once it goes to them. Once it's gone to them, well, it's gone. But in terms of that, you can still retain a lien across the financial data as well, even though strictly speaking it's not a chattel. But again, strictly speaking, if you don't want to do it in contract, you want to actually physically have it somewhere, you can still store it electronically on your system. That's fine. But again, things like that, I think strictly speaking, you'd probably, and I'm thinking more of the days you go and you'd print things out. Lawyers, I taught trust accounts this year. There's a whole bunch of things that say we actually have to print stuff out, even though in this day and age of electronic this, that, and the other thing, they still have to literally print out all the trust accounts every month and physically store them for 7 years because of reasons. And it's those things you could have liens on it as well. It's supposed to be tangible, yes, in terms of having a lien at common law. For intangible stuff, strictly speaking, you could argue that the data inside your computer counts probably wouldn't work, I wouldn't think, because it's really your intangible stuff in terms of on it. I don't really know. I'll have a think about it. Because you'd almost never use the common law lien rules anyway, because at common law you can't do anything with it. You can hold on to it, but you can't sell it or pass it to a third party or do anything else with it. Whereas if you had it in a contractual arrangement, you do whatever, have whatever in terms of doing it. And anyway, often the data is worthless to you. That's the other thing too. You got your client's data. Okay. So just make note, this general lien, all right, and this is important in that you can have, as a solicitor, if a debt is owed for a whole bunch of matters, okay, there's a little bit of complexity there, but that's, you can, when another matter comes in and this packet of documents has come in, you can hold on to those documents for this matter until all of these other ones are paid for, in theory. Again, there's a bit of statutory trickery there, but in theory, that's the way that works. And the same with stockbrokers, insurance brokers. They can retain hold of a bunch of documents until all of the debts are paid. Whereas the special lien applies to a particular asset. So your motor mechanic, for example, doesn't get the right to do that. If they've got 2 cars, you've got one in, you haven't paid for it, and it's sitting there, all right, and they've got another one in, you bring it in, and you get them to fix it. And then you come and pay for the first one, they can't stop you from taking the first car away after you've paid for it. All right, they're not allowed to at common law because that lien only applies for the debt arising from each particular vehicle, each particular thing. All right, so that is the last useful thing. There's one slightly less useful. I just love this telling the story because it's not just a Queensland case, it's actually a Townsville case. It's really funny. Irving and Heffron involved. This is the case in, I think, in all of Australia to do with a thing called the common law innkeeper's duty. And for some reason, this has actually come up in my legal practice, community legal. It turns out if you go somewhere and you stay somewhere and you buy drinks, and in the olden days, you used to use the phone. I suppose these days it might be the internet, wireless internet or whatever. You can get food, you can get drink, you can get a hotel stay, and curiously, there's a 2-way lien that applies here. Firstly, if you don't pay for stuff, the owners can hold on to the stuff that's in your room until you pay. Secondly, they have a duty to make sure the stuff in your room doesn't get nicked. There you go. In a hotel, common law, if you go to a hotel, they have a duty to ensure that your stuff doesn't get stolen. That is modified by statute in Queensland, it's capped at $250. But if you're in a hotel and stuff gets stolen in Queensland, you can say, I would like to exercise my rights under the, strictly speaking, under the common law, as restricted under the Travellers Accommodation Providers Liability Act, Section 12, which caps it at $250. It's not very much money. So it's a 2-way. This is interesting because it's actually a 2-way streak. They have to sort of insure your stuff, but they can also hold on to your stuff. And the reason why I find this kind of funny is the case, which is Irving and Heffron, involved the Vale Hotel. Whenever you guys are going down to Dan Murphy's, down at Aikenvale, and there's these little hotel bit they have at the back, these old blocky, ugly buildings. Anyway, back in 1992, some guy was staying there. Now, back in the olden days, before mobile phones, you had to use landlines, right? And so the guy who was staying there was a bit of a disagreeable gentleman, and he had some food, was staying there, and used the phone. He used the phone and called like interstate numbers, racked up a really big bill. And that day, that afternoon, the publican found out, marches into the room, and the guy's half awake, half asleep. And the publican goes, what are you doing? You got to come and pay for this. And the guy who's half asleep goes, piss off, mate, get out. And so the guy half falls back to sleep, so the guy grabs his bag and grabs his wallet and wanders out. And it's like, okay, that's the thing. Well, the trouble was, when he opened up the bag, it was completely filled with marijuana. So what's the problem here? Well, the problem is, when this went to the Queensland Court of Appeal, is that for a criminal matter, because this is to do with the Crown prosecutors, evidence has to be lawfully obtained. And this evidence would have been lawfully obtained if the common law innkeeper's right was invoked. The guy didn't pay for his phone bill, therefore, the innkeeper has a lawful right to go in and take goods to the value of that. All right? It's good. The trouble is, the publican went and grabbed the bag and took it out, and also grabbed the wallet and took money out of it. All right? Money is not chattels within the meaning of lien. You're not holding a lien across that. You're just literally stealing money from somebody. And so the argument was it all of the assets, all of the chattels that they were trying to argue was invalid, or was it just, could you separate the two of them out? This is the sort of thing that ends up going to appellate courts, because this law is 1,000 years old. Common law innkeeper's lien. I just thought it was hilariously funny, because there they said that, look, in regards to the bag of marijuana, all right, the common law innkeeper's lien, 1,000 years old that it is still good law. You don't pay for your stuff in a hotel, they can come into your room, grab your stuff, take it out, hold on to it till you pay for it. They have no right to sell it, but they can lawfully do that. Therefore, that evidence was lawfully obtained. Therefore, you're going to jail. That was that. That's that. So anyway, I know that's strictly speaking a criminal case, but I don't think you guys are worried too much. Anyway, that's the last slide. We can all go home. Yay, go home. All right. As I said, next week we're doing intellectual property. I'll send an announcement out. We're going to move. The feed for date for this is going to go back a week. And the assignment due date is going to go back a week as well. And I'll book a room and tell you guys what the room is for the exam. So anyway, thanks team. Hope that was useful. And yeah, I guess we'll hopefully see you guys